on one and won't be joining us. So we have three members of the Board of Appeals here. One is appearing virtually. So I guess the first order of business would be for someone to make a motion for one of the other two to handle the chair duties for the meeting this evening. And my recommendation would be that it not be done virtually, but it's up to you.
Since I'm the one appearing virtually that he doesn't want to chair the meeting, and I do not want to chair the meeting, I move that Wendy Smith be acting as chair at this meeting.
Is there unanimous consent for that? Anybody opposed?
No.
All right, if you want to, up to you if you're more comfortable chairing from where you are, if you'd like to take a seat next to the clerk. Heard that before. Is the
I have a green. Oh, there we go.
there it is.
A green
All
light.
right.
I'm number 9. Okay, well, this one's 10. Okay. I call to order this meeting of the Shorewood Board of Appeals on this day, Tuesday, May 10th, 2022 at 5:56 p.m. Apologies for the late start. Clerk Harrell, can you please give us a roll call?
Wendy Smith,
Here.
Michael Polson,
Present virtually with the consent of the chair and staff.
and John, your last name, I'm sorry.
Tottenhoff.
John
Tottenhoff.
Tottenhoff.
The traditional spelling, right?
Yes.
And Clerk Harrell, may we also have the statement of public notice?
The meeting has been properly noticed and posted in accordance to law.
Thank you. Okay, the first order of business on our agenda, which is included in the notice packet for tonight's meeting, is consideration of meeting minutes dated March 8th, 2022. Do any of the board members have any suggested corrections to these meeting minutes?
No,
I have none.
Hearing none, may I have a motion to approve these minutes as proposed?
I move
Oh.
to approve.
and I'll second.
Thank you. All those in favor of approving the meeting minutes as proposed for the meeting on March 8th, 2022, say aye.
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 All those opposed, say nay. Hearing none, those meeting minutes are approved. Next order of business is consideration of the meeting minutes dated April 12th, 2022. Do any of the board members have suggested corrections for those meeting minutes?
I have none.
No,
Okay. May I have a motion to approve those minutes as proposed?
I move to approve the minutes for April 12th.
Thank you.
second.
Thank you. All those in favor of approving the meeting minutes dated April 12th, 2022, say aye.
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 All those opposed, say nay. Those meeting minutes are approved. The next item on our agenda, Attorney Bayer, how do you want to handle describing the standards by which the board abides, given that we have multiple different types of review items tonight? You want to do it all in once, or do you want to separate it?
Oh, thank you. I think it would be easiest to separate it because the first appeal is an appeal to interpretation to allow relating to the interpretation of the code. The second one is a special exception relating to a site plan. And then the third one is a more traditional variance that's typically held by the body. Since they're very vastly different, I think it's probably best to break that up.
Okay. Unless there's any objection, can you give us the standard for our first item, consideration of appeal for the Plan Commission's discretionary decision pursuant to Village Code 535-21B C2.
Certainly. Because this is a little bit unusual, I can't remember another appeal in my time working with the Board of Appeals that has dealt with a build to line on a side yard. I think it might be best to give a little bit of context as to the specific decision that was appealed from and sort of how we got here. There was a memorandum that I drafted, sort of laying these things out and analyzing, and I certainly don't want to go through all of that because I know everybody has other places they'd like to be this evening and things to do, but I do want to highlight a few of those. So the specific item being appealed from is the Plan Commission's January 25th, 2022 decision that approved the side lot, what we call a build to line on the proposed development at 2418, 2420, and 2428 on East Capitol Drive. So I'm going to sort of refer collectively to the appellants as the Neighborhood Association. They filed an appeal to interpretation to allow. So I think it's important to start with the zoning code that's being appealed from and give a little bit of an explanation as to how that code works and what was before the Plan Commission, because I think it helps inform the decision of this body. So Shorewood zoning code dictates that for any proposed construction on a corner lot in a specific district, in this particular case, what we're calling the B2 mixed use residential district, the build to line on the side of that lot has to be reviewed by the Plan Commission. So what the code specifically says is on corner lots in that district, says that the general build to line is 20 feet from the street curb line. And then it says, except that the side yard setback on corner lots shall be reviewed by the Plan Commission to determine whether a 20-foot build to line or another corner lot side yard build to line is appropriate due to parking considerations and the layout of the intersection. So in other words, what the Plan Commission can basically do is push the build to line further back due to some very specific issues if they see them, and that relates to either parking considerations or the layout of the intersection. Just as an example that we talked about at Plan Commission, if you had a corner that maybe wasn't a normal 90-degree, or maybe you had something where there was a difference in the width of the roadway as you approached that area, and if you did the build to line on the narrower area as opposed to the wider area, you might have vehicles pulling out into traffic that people would not see, those type of things. So when the Plan Commission was reviewing this, their review was very limited to that one issue. And they couldn't just willy-nilly say, well, we want you to move the build to line. That they have to have a reason to direct the applicant to do that. So they have to have some kind of substantial evidence to move the build to line further than 20 feet back. So what they did at the January 25th, 2022 meeting is the Plan Commission had a discussion of the layout and all of those things. And they looked and they talked about how in this particular case, because of the way that the lot is, it's actually slightly further back than 20. I think it was about 22 feet back from the lot line or the build to line was about 22 feet. So it was a little further back than normal. They didn't see any specific concerns or considerations associated with that particular intersection, and they declined to exercise their discretion to move the build to line. So there was a appeal filed by the Neighborhood Association, and there's a couple of issues that I wanted to address in there. They filed an appeal to interpretation to allow, which challenges the Plan Commission's approval of that build to line. So the jurisdiction, again, is limited to should the build to line be 20 feet or should we move it further back based upon what the code tells us on this individual circumstance. There's a couple of issues raised in the submissions that go with the appeal that address issues that were not under the review of the Plan Commission, and in my opinion are not under the jurisdiction of the Board of Appeals here. Section B was titled lot coverage. Again, that was not an issue that that the Plan Commission evaluated. And then Part C was titled 10-foot setback. if adjacent to a residential neighborhood. Again, that was not an issue. That was before the Plan Commission, so is not, in my opinion, before the Board of Appeals. So the appeal itself is a bit of a mystery because it doesn't say, well, we think the build to line should be 22 feet or 28 feet or 30 feet, or doesn't suggest any alternative build to line in there, but the appeal, you have it in front of you. So at any rate, there's a couple of things to take into consideration. The first issue is whether or not there's what we would call standing to raise the appeal. It can be evaluated by the Board of Appeals. The ordinance says that to file or appeal the decision of another body, you may be aggrieved by the administrative order, decision, or determination of the municipal body. And so you can evaluate whether or not they've raised any issues to demonstrate how they were aggrieved by the decision not to move the build to line. Whether you believe that they're standing or not, I think it makes sense to address the underlying decision of the of the Plan Commission. And that is to determine whether or not they relied upon the correct applicable ordinance and applied it properly. In other words, did they evaluate the ordinance that told them to evaluate the 20-foot build to line and make a decision whether to move it or not? And a municipal body under the applicable law proceeds on a correct theory of law when it relies upon the correct ordinance and applies it properly. And if you believe that the ordinance was applied properly, and you believe there is substantial evidence to support that, you would either make a motion to affirm, reverse, or remand the recommendation or order of the lower body. So Village Code 535-51 gives the Board of Appeals the following options. It says the Board of Appeals, after a hearing, may affirm, reverse, or remand with recommendations any order, requirement, decision, or determination of the Plan Commission made under this section. So my recommendation would be to evaluate the 20-foot build to line and whether the Plan Commission proceeded on a correct theory of law and relied upon the correct applicable ordinance when it applied it. The way that this would proceed is the applicant or the applicant's representative would be allowed to make a statement or argument or offer additional comments concerning their application to the Board of Appeals. You would have the opportunity to ask any questions of the individuals speaking on their behalf. You would have the opportunity to discuss amongst yourselves and then consider any motion. That would be my recommendation on proceeding.
Okay. Now, typically, do we hear a representative of the Planning Commission first or from the applicants?
I don't know that, is there anything, does the Plan Commission, on behalf of the village, is there anything that you have or?
No, there is no representative from the.
Okay. So is the procedure then to open this to?
If you want to take, if you would like to invite comment or argument or summary of the appeal by the applicant, this would be the appropriate time. Then you could open up to the body for any questions concerning the applicant's appeal. And then discussion and entertainment of a motion, move forward based upon what the will of the body is.
Do we have a representative for the applicants? Again, use the podium, please.
You hear me? Is that good? Close enough? Thank you. May it please the board. I'm Joe Sincotta. I'm an attorney. Shorewood. I'm representing the association, Capital Neighbors, and referred to as the applicant applied for the appeal. I'll refer to us as appellants. Focusing then to respond on what Attorney Baer discussed and trying to present this, I guess, clear up the mystery. Really not a mystery. The primary argument being made by the association, their attorney, that the Plan Commission didn't fully exercise that otherwise they implied the ordinance too narrowly. So when you make that kind of an argument on appeal, that's a legal, not one that needs evidence. The way you sort that out is you look at the ordinance, look at what they did, say, well, and what they said about the ordinance, say, well, did they apply that ordinance properly? That's a legal determination. So our primary argument was corner lot setback ordinance, which Attorney Bear properly read into the record. I'll do it again. Corner lots shall be reviewed by the Plan Commission to determine whether a 20-foot build-to line or another corner lot side yard build-to line is appropriate for parking considerations and layout of the intersection. So that language needs applied first by the Plan Commission. And the point on appeal is we don't believe the Plan Commission properly applied that. That's I think your task. From our perspective, that's your task on that. Did the Plan Commission, based on what you're able to review, interpret what that ordinance means and properly apply it? We don't think they did. Give a little reason why in a second, or a little reason why. But because of that, we are not asking for a particular side yard setback, not asking to change it and make it further back. That is the desire. But what we're asking for, proper relief from our perspective, is send this back to the body that has primary jurisdiction about adjusting that side yard setback under the circumstances. Say it again. Don't believe that Plan Commission properly enforced that ordinance. Properly enforced it too leniently and too narrowly. And my review of what they did at the meeting was that they really did not articulate what the purpose of the ordinance was. They could then properly apply it. That was with one exception, which I think one Plan Commission did say that seemed to her the ordinance was about safety or traffic and otherwise. As you envision a building on a corner, it gets closer to the corner, the sight lines for traffic are obviously finished. So that process we don't believe was properly carried out. Need to acknowledge what the ordinance is for. Safety concerns driven primarily by traffic, pedestrian and vehicular traffic on that corner and on the adjacent streets. And then have some discussion about whether there should be a reason to make that setback bigger or into the lot, or perhaps less. But it seems to me safety would suggest that the building pushed into the lot further so that it's a safer intersection. Again, that was the view of certain Plan Commission members, that should be done. It was not done from our perspective. Others may argue, and you might get advice from counsel that, well, the Plan Commission did this, I believe that is sufficient to properly apply the ordinance. That is your task on that question for us. What the Plan Commission did sufficient, both from did they understand the ordinance properly, apply it, and did they have evidence to support their conclusion? We don't think they did either of those properly. That is primarily a legal determination for the body. Again, I'm asking that based on the record, agree with us, send the issue back to the Plan Commission. Seems to me the obvious interpretation, the obvious purpose of the ordinance is to allow the Plan Commission to address the safety of an intersection when a large building go up. Again, discussion of the Plan Commission really focus on that. Staff gave advice and they had their perspective on what the purpose of the ordinance was. And so a challenge for us is to ask this body to say, well, we think staff was correct. The language of the ordinance requires that you do a thorough, broader review about the safety of that intersection, given the current proposed building footprint. Position of the appellant would be that it should set back further. That is consistent with the underlying neighbors that the building is large. This is one manifestation of that. maxing out up to the build-to line on all four sides. So a legal determination on that issue, that's the primary question. Ellen. A little bit now on another procedural issue. The staff did a plan zoning review in advance of the plan commission. That memorandum was attached part of the packet that the plan commission fifth. The specific staff report of 8th of January did address just the corner setback issue with some further elaboration. Again, the difference in opinion raised by that memo. But the fact that the zoning review was done by the commission, by the staff, that was presented to the body, we believe does bring up some other regulations that were kind of incorporated into that decision by the plan commission. Specifically, the rear and side yard setback rules. And so in the appeal, those are addressed. You think those are appropriate for the body to consider? May take a different position, but to explain it, I don't think that it's so sensible for the Board of Appeals narrow what it reviews down based on, well, this appellant made this appeal and this was the only thing that was thoroughly discussed. It's the village through the plan commission made a determination. Determinations included that the building satisfied side and rear setback. Those determinations were kind of swept up in the discussion of the more confusing one, but they were determinations made nonetheless. So we believe that it's appropriate and reasonable for us to ask the body to review those as well. Although I think there are other avenues for that relief. And so that would be the rear and side yard setback. Side yard setback on the west, 10 feet because building borders residential subdivision, zoning district, similarly the rear yard setback. So that's a legal argument, a legal memorandum, if you will, a summary of the legal points Ellen has made. Mr. Dan Walsh, who's the representative, I think wants to make a presentation on factual matters that are at issue. And then I'll just be here and answer questions if needed. Otherwise, that's my.
You said Mr. Walsh.
Point of order for Mr. Walsh. I assume that we're here on a certiorari review, which would mean that no new or additional facts other than anything that was presented before the plan commission can be entertained by the Board of Appeals. Is that correct?
What is the
Mr. Walsh, I'm sorry, can you get a little closer to the mic? Yeah, sorry.
Mr. Paulson, what is the extent of the record then? You just said I can't bring any new facts, and I understand that, but we're talking about the record that exists here all the way back to February of 21.
We're talking about the record before the plan commission and in the packet before the Board of Appeals. And any that are related to the issue before us, which is the appeal of the east side setback.
Okay, so this working okay? Everybody can hear? So I'll try to make my comment much like Attorney Bear. You need a little. The reason the neighbors are here, we are here because if not by the staff at this 15. We think that is because certain people, certain elected staff members are anchored to a decision that was made in February. And moreover, this year, there has been unending disregard. All of the neighbors, virtual unanimous opposition, continually brought facts, data, table, simply waved off. the developer has made, and in the record, he's made substantial misrep graphics. Say cited wrong standard, misapplied, didn't apply weekend. It misunderstood the limitations of the parking lot, didn't have the right regulation, street park. All of that waved off to convince the plan commission back June 1st, submitted MIT study that was to contextual, important contextual. They submitted with their application June 1st special exception hearing, a 120-page report dated professors January of 2005. The data in it filed from 4 to 2. It occurred in a jurisdiction over 1,000 miles in a city, 350. It also has a mass transit that is 1,200%. The information that was provided to make the decisions the Plan Commission made was completely. They knew what they wanted. They knew they could get the votes. They ignored all of the facts all of the neighbors brought. We're here today. We made the appeal. In fact,
Well,
Because-
might I make a comment?
Yep.
Might I make a comment that we're not here to rehash?
No, we're
the
not, but
Decision on this special exception. We'd like it to stay focused on the decision planning commission on January 5th.
read. We're gonna get there very short. But context is every step, 18 months, staff has heard of the data provided, accepted data that demonstrable or inapplicable. And they've also denigrated in the process, change the zoning code, our special moot. They're all things that the village is fighting us tooth and nail, and they still have no substantive background. I'm reading this because Bart's testimony. So Bart was asked why we department by one of the, and this was in my, says, quote, I'm sure 1.75 ratio calculated decades by industry standards. Respect to an engineer did a survey in a multifamily building in a city somewhere that identified that was the need of units. Then just over the decades, years, whatever, other municipalities have adopted similar regulations. So I have no reason to believe that the 1.75 was crafted fine. Very likely, probably just adopted it because they're, Brookfield, Milwaukee, Cleveland, someone else did. So we do have the right to make that fit our local needs. So if in Shorewood we had a more robust public transportation system, take that down. Had a more robust. If we're out in New Berlin, where we don't have that kind of, obviously different. So I don't have an answer where it comes from, but I would suspect not locally derived. Our zoning code, zoning administrator, denigrated the zoning code moment in front of the plan commission, saying it doesn't matter. The same thing just in the meeting, you all So the code section that we were talking about introduced. Attorney Bayer, what he said. Bart and I were talking about this earlier. I was thinking of a hypothetical example that might present itself. Him to demonstrate many, many decades ago, a particular provision may have been put there. The only thing I can think of could come up with, there was an unusual corner somewhere at sub 90-degree angle corner. There were a couple of municipalities west of Oakland Avenue, very wide, and they narrow. The other end of this, then it goes on. Vision. So the staff and the village are saying, hey, this doesn't, none of this matters. We don't even know why this is in here. So there was really no substantive discussion about whether there was no substantive discussion. Bart went on to say that had talked to it. DOT does not have whether this is safe or not. Nobody evaluated it. Nobody provided any data, whether good or bad. Across the street from this very property, 18th switch box, been in packaged pictures of that switch box. Whatever, 15, 20 years ago when that was put in, we said, hey, please don't put it here. There's a bad place for it. Really badly obscure vision triangle. For you, putting it where? The time 15 years in the state of Wisconsin for a time. Purchasing easement, doing exactly those kinds of subject matter experts who were told to go away. That with Chris, hey, why don't we, you're going to make sure you do this. Why don't you make sure, why don't you, an agreement, the village should be paid for it. Who's going to take care of the landscaping? There should be a picture in your packet that looks, well, it looks like that all the time. From the alley, you cannot go often out of the alley, somebody flying off Capitol Drive, very close. Now, what we're doing here is adding 42 one corner, the same number of units, the entire street, whole Capitol all the way to Jarvis, and there is no rational about whether it's a good thing, bad thing. There is just fluff. We don't make any attempt what needs to be done to evaluate. On top of all of that, the plan commission looked at, not even the plan anymore, because we're so backwards in this village. We separate the decision so that developers, village work together to the detriment of all the neighbors. We've separated it all out. Previous plan commission members, PRB members, they all want to know why their scope is so limited. Purposely done. Right now, we have a new plan. It doesn't even look like the plan commission made the decision back in. So if for no other reason, then it's not even the same damn plan that they made it. Should send it back. The other thing in the setbacks, so I practice in this area, broker. Planning commission, very really give them. So to say that they are limited, exactly what, if you watch the video, Attorney Bayer over and over, limited to this, we're limited to this, we're limited to this. Parking layout. Don't talk about what layout is. What is layout? No definition. So the layout is setbacks of the other buildings in the area. We've provided detailed analysis of what the setbacks are from Murray. The setbacks are much bigger than only properties that are setback, very, very small. Anywhere in this district, 1 and 2 stories. Everybody else has biggest buildings 1 block away, 4-story building, 27. They line up with the houses. There was no discussion about whether maybe we're building something that's no conversation. I just think that the residents are a much more very salient, just not get waved off. A foreign developer comes in, garbage into the this property. Anybody know when it was? I mean, it was around 2014. It was before that there were meetings. The then planning director Eric Wang, reports were in the room. 3 of us. Whole discussion was 4-story, always going to be all that was ever. And here's what the says: B2 mixed-use residential district is intended to provide opportunities for mixed-use development, urging residents. The district allows for exclusively residential use, mixed-use residential units, retail office, buildings exclusively commercial use not permitted. This district will allow additional adding residents. I read that because it's just perfect. Crafted an ordinance, get all the residents. That's cool. We're talking about mixed use. Nowhere in there that really means because it's parking on the. So what? Go to the comprehensive plan meetings, visual preference survey that we. Everybody has an idea of what they want. Mixed use. But the last that were approved, Swimmer project, they're straight residential parking structure. So this idea of trying to zoning code in the village, because you have transparent, it's being destroyed by the current administration. For what it's worth, I think that the residents here much more. And I think that the village attorney, they think, toss on. What the body, they're just poisoning the well. Everything that happens is really something. Stop. Finally, I wanted to add one thing to the record. Setback. The rear setback. What it says is that if the property abuts an alley, rear setback. Property line. Reading the code. And here that section 535 6 defines an alley as a public or private right-of-way, secondary, particular street, public or private right-of-way, primary access. Alley behind this building. Setback, rear setback. I hope you'll send this back. This project needs a ton of work.
Thank you. I'll open this up to questions for counsel for the appellants by the board members.
I have none.
Perhaps I can get clarification on the appellant's position as to what the appropriate side setback should be for this building.
Excuse me. Thank you. On the Dole Capital Corner, that determination by the Plan Commission, I believe it should be substantially more current to allow for vision. And if we have a Plan Commission meeting where that issue is addressed in that fashion, then we would bring to bear our own analysis, et cetera. We don't look at this hearing as a place where we have you decide what the so a long answer. The west side setback, that seems straightforward out of borders. The west side is not, I don't think currently 10. I mentioned the plan is changed, but that should be 10. That's a pretty much great plain language application of. But this corner side yard setback is discretionary. That would generally, we would like it to be more than it is, but I don't have a number. Walsh actually may be able to give you a better number because he lives right there. But the point of our argument, when I go back to make that argument, have it be genuinely Plan Commission level. So that's it.
Thank you. Any other questions?
I have none.
Mike? Questions? Okay. I suppose we'll proceed. Are there any other comments from, is there a representative for the developer of this property that would like to make a comment? Any member of the public that would like to make a comment? Okay. Hearing none, I suppose we can close the open hearing portion of this consideration and move to deliberation amongst board members.
Well, I'll open that up. And this, we've talked about this corner quite a bit so far. So it seems like there is an awful lot of planning that's still going on around here. And every meeting that I've been a part of for the past several years, if there's any opposition that comes from any one of the neighbors, it bears a lot of weight. I just can't look past that. This is definitely coming before us because there is a lot of opposition coming from the neighbors.
So do we agree that the standard that we're looking at for the side setback for a corner lot is to see whether the Planning Commission on the 25th of January considered parking considerations and the layout of the intersection at that intersection as to whether the side setback should be pushed even further than the stated 20 feet from the street curb line, and whether the record, the meeting minutes and recording of the meeting on January 25th supports consideration of substantial evidence. Does anyone have any commentary on the the evidence considered at that January 25th meeting as to whether we can show substantial evidence was considered for not taking action to push the side setback even further than the 20 feet.
If I could jump in, it seems to me, as to your question, it goes to the issue of application of the particular ordinance, and the ordinance is discretionary on the part of the plan commission to increase the setback from the standard build-to line of 20 feet. And it would, and given that that's what the ordinance is, it would require substantial evidence for them to act to increase that 20 feet. And quite frankly, I've reviewed the entire record. I've listened to the entire video transcript, and I find no evidence other than some generalized concerns about safety, but no specific factual evidence that would say that any other line, whether it be a foot more or 10 feet more or whatever, would have any impact on the standards set forth in the ordinance with respect to parking and the unique nature of that particular intersection. There was no evidence, no factual evidence, certainly no substantial evidence that would support a plan commission decision that would justify a greater setback. And that if the plan commission had done that, I think the developer would have had a significant basis for legal challenge. And certainly a developer would have standing if in fact the build-to line had been moved back, contrary to the current situation where I'm not sure that the appellants have any standing. As I understand, person agreed, it requires some sort of individual particularized injury caused by the decision of the plan commission. And I can't see how any of the appellants have been injured by the decision not to increase the, have any particular individualized injury by the decision of the plan commission not to increase that setback. Obviously, I'm willing to go to the merits because it's been more than 20 years since I've litigated at any length standing. And so there may have been developments in the law that I'm not aware of, but it seems to me that there's no one that's particularly aggrieved. So we have a combination here of no evidence to support an increased setback with minimal, if any, standing on the part of any of the applicants to challenge this. The fact that there are neighbors that oppose it does not go to the issue of before either the plan commission or the Board of Appeals, which is whether or not the plan commission had substantial evidence to support its decision and the decisions over which it had jurisdiction. So that's my 2 cents at this point.
I tend to agree in that after review of the minutes and the recording of the meeting on January 25th, the default is for the side setback for a corner lot to be set at 20 feet from the street curb line. If substantial evidence was proposed and introduced and considered by the planning commission, they would have that discretion to push the side setback any number of feet or inches or what have you on the basis of some demonstration that there is something unique about this particular intersection or this particular lot line, given the parking considerations and the layout of the intersection. I did not see from the record anything substantial showing that the intersection was particularly unique from any other corner lot in this same mixed commercial use type of usage. So I'm not sure if I'm okay to proceed on the merits. I may have jumped the gun on the issue of standing do we, Attorney Bayer, could we seek comment from counsel for the appellants on the issue of standing at this point?
It's at your discretion. The applicable code provision is 53552. And it talks about allowing citizens who have been aggrieved by administrative order, decision, or determination of a municipal body to appeal that decision.
Would counsel for appellants like to make a statement on the issue of standing? And specifically, how your clients have been aggrieved, or as Attorney Bayer mentioned about the issue of meeting the criteria of standing?
Standing is not something you need. You don't have to prove injury and have standing. Fundamental premise that needs to be good. I think Paulson understands that. Standing in these types of cases derive from the proximity of these properties to the project. So project is being approved under a particular version of the ordinance or interpretation thereof. If it is so approved, it will harm the neighborhood. Those assertions, those allegations are made in the record a lot. And basic facts are the truth that the properties of appellants are really right next door to this project. And they also live on the street. Living on the street and the traffic issues are perhaps more central to this particular issue. So the standing of appellants is manifest, obvious. They are the classic example of who would have standing in their adjacent property owners. As an example and an analogy, the state statute that enables zoning law at all specifically provides that adjacent or surrounding property owners standing, it would be specially damaged by the project that has been approved. So we have standing. Say it again, we don't have to prove, for instance, with a real estate or expert that our property values are going to go down if this building is built, although it's manifest they probably will. We have to assert that. And if the law is such that typically this type of property owner has standing, then we have standing. And so under that standing, the term aggrieved comes from the statutes as well, and the common law, chapter 68, aggrieved person. Notice it says not the applicant. Contemplating, as here, adjacent or other injured property owners or taxpayers. So aggrieved means, said, potential to be injured by this project being built contrary to the ordinance. Contrary to the ordinances as perceived by the applicant, challenger. One final note to give context how easy, how the courts broadly construe and allow standing is next step in this challenge the Board of Appeals determination. Statutorily, any taxpayer in the village can challenge and go to circuit. It would be absurd to say that the neighbors next door don't have standing to this body. Then the determination made here, any taxpayer can challenge. Highlights the idea that standing is not a very difficult barrier. Have it here easily, given the proximity of properties. That would be my question.
Thank you.
Moving on from the issue of standing, there's one, if I may, one other point that I think we should address and discuss, and that is numerous other allegations and representations and challenges to other actions of the zoning administrator have been made, in particular with respect to, for example, green lot coverage and setbacks from alleys, residential areas. First of all, they are not part of the appeal because they were not within the jurisdiction of the Planning Commission and were not part of during the Planning Commission's decision, which has been appealed. So therefore, those issues are irrelevant to that. Secondly, I think one could make a pretty reasonable argument that the adverse decision that with respect to all of these other items in the administration of the zoning code occurred when the zoning code administrator made the decision that the entire proposal, I think we're back in January, I don't remember the precise timing, was in compliance with all other aspects of the zoning code. That was the relevant decision. And that would have to be appealed if there were an agreed person resulting from that review, and that would have required an appeal within 30 days. So it seems to me that at the very least, this is an untimely attempt to challenge the zoning code administrator's code review decisions. To first bring them to the plan commission, since they weren't, that was not specifically before the plan commission, and now to attempt to bring them to the Board of Appeals. So I think they are irrelevant to any decision before the Board of Appeals here tonight based on their east side setback decision.
I do agree that the agenda for the January 25th meeting was specific to consideration of the side setback criteria. And although I do note that the issue of lot coverage and green space was raised briefly at the January 25th meeting, it appears from the record that the Planning Commission was focused on its review on the issue of side setback only. I suppose I agree with Michael Paulson that our review is limited to what was on the agenda for the board, or excuse me, the Planning Commission, and its decision, which was limited to the side setback. Yes.
And the thing we're asking is finding by you consideration. We understand there was not substantial any kind either direction. We're simply saying matter not properly considered instruction and commission error. And they made light of what was actually, and so the Plan Commission didn't even go into things that might be by them with respect to layout. None of these things were discussed. That is one issue. And the second issue is a plan moving forward today, not the plan presented at the previous meeting. So whatever action the commission took, it's moot. The same plan, a very, very different plan with the driving is now moving forward. So if there is an issue of safety, if there is an issue of parking, that needs to be, because it's a different, those are the two.
I don't believe that we have any evidence in the underlying record of a new plan, do we? I mean, if the argument is that this appeal is moot, is it appropriate for the appellants to withdraw their appeal?
Will the developer bring the new plan to the Plan Commission for consideration setback? Because it's a completely different. The building has
That's
changed.
not an answer I can give you that within my purview. But if you're saying that this consideration here is moot because the plan is now null.
No.
then-
So what has happened is the village has continued to move approval forward. And in the process, went from the plan commission to DRB. DRB said no. They said no again. And then a completely different plan, a completely different driveways in a different place, access place, the front entrance to the building, completely different building materials. A completely different plan was submitted by the developer and approved by the DRB. So the side setback, to the extent that anybody in the village cares, right, that it's a different building and a different plan with all kinds of different considerations. It would be silly to the plan commission has to approve the side yard setback for parking considerations and layout considerations, and then change the plan and use the plan commission's action on the previous plan. That seems silly to me.
I agree, but it seems as though we can only act upon a decision by the planning commission. And the decision that we have before us is the decision made on January 25th.
The other way. So if applicant, developer, plan commission, zoning review, that occurs at the plan commission makes a decision. And then we appealed it, which we did, actually timely appeal, put in the side yard setback. If the plan has changed. Now, that's not in this record. Walsh has asserted it. I don't think there's a dispute about that. Body could say, look, are we dealing with the same thing that was being dealt with in January? If not, it wouldn't go against us. It would say, well, let's find that out. If it's a new plan, plan commission should review it, zoning review compliance. Sometimes what'll happen is the staff will allow changes creatively without hearings. They'll kind of move it along and say, well, that earlier plan commission meeting basically approved the same thing substantially, but we're just going to keep going through. That would be a judgment that would be made, but from our perspective, the plan is substantially different. So if you're going to inquire on this issue, which I think is reasonable, it's not moot from our standpoint, but current approval is void because it's based on a plan that no one. That would be our thought. Applicants, remember, they're looking for approval. They would then have to come and say, well, we want the new plan to be approved. Well, have another round, etc. Now, often I've an idea up to staff kind of allowing for projects. These weren't tweaks, but what Attorney Bear is going to tell you right now is they probably were fine forward. We would not agree. We think you're absolutely right. Current plan in front of you avoided back then half in the back to plan. That would be my.
Bottom line, what I think I have just heard is that since staff conducted its zoning code review and since the planning commission made its January decision, there has not been a significant change in plans for this particular project. Therefore, the whole argument is beside the point.
That's exactly the opposite of what we asserted. I'm saying that is an issue that needs to be addressed. So I don't want to be misquoted on the record. We think it's been substantial. The fact is that plan is not in front of the body. That determination needs to be made, probably not through me arguing it or Mr. Paulson. I said needs to be examined by the body, determine if the plan is different, and if so, what would this body do because of that? But I did not say that there hasn't been changes, just the opposite. I think there have been that are material to the issue.
You have a comment?
Yes. Justin Burris, building inspector with the Village of Shorewood. The term plan is being used very generally. And my question would be, has the build to line that the developer proposed changed? Again, the design of the building is not what the Plan Commission reviews. It was specifically the build to line of the building. So when we say the plan has changed, I would like to bring it back to what they were reviewing is that build to line, and that has not changed.
So Attorney Bayer, how do we justify a decision here based off of what appears to be he said, she said?
No, that's a great question. And, I understand what counsel's, saying, and obviously that's important to him and his clients, but what this body can just do is evaluate the record in front of it and evaluate whether or not the Plan Commission acted appropriately at the January 25th, 2022 meeting. If there's something, and I don't know, I haven't looked at any quote unquote new or altered or other plans. But obviously if, in the future, if something is withdrawn and resubmitted, or if there's a substantial enough change that it has to go back through the normal channels, there'll be another kick at the cat at this. I don't know the answer to that one way or another. I just know it's unfortunately not in front of this body right now. The jurisdiction is, what did the Plan Commission do on January 25th, 2022? And I think, and again, it's obviously everybody's, has different opinions on the property itself and what's good or what's bad for the neighborhood, and everybody understands those things, and those are obviously understandable and valid and all of that. But the issue here for this body is, what did the Plan Commission do? And, to Commissioner Paulson's comment that there's a default 20-foot line, there's a default 20-foot build-to line. And when you have a developer that comes in and says, okay, well, here's my plans and specifications that otherwise meet the zoning code. If you're going to move the build-to line off the default setting, you got to have a good reason to do that, and you got to have substantial evidence to tell them, well, we want you to move it further back. And so the question is, was there anything in the record that suggests that they should have done that? Because, for the tough position for the village to be in is, if there hadn't been substantial evidence to move it, and they had just said, well, move it back to 30 feet, we'd be getting sued by the developer as opposed to the neighborhood association. So it is what it is. But it doesn't, whether or not the plans are changing or going to be resubmitted is really not an issue before this body right now. The question is, what was the decision on the limited scope that was under review by the Plan Commission on January 25th to decide whether or not to move the build-to line off the standard default, which is 20 feet. That's it.
I would propose that we proceed with Attorney Bayer's suggestion in just simply looking at the record of the January 25th meeting and allowing the opportunity for the association to take up the matter of any new plans with the Planning Commission itself. That does not seem appropriate for us to wade into that matter. When before us, what we have is a fairly narrow question of whether it was appropriate to keep the side setback line at 20 feet or some extended feet. Any deliberation amongst other board members on that decision?
I concur with your analysis.
John, any comment?
Yeah, agree with them.
Okay. So looking at the record before us for the January 25th meeting where there was a vote, Planning Commission decided, I forget what the official vote was. Regardless, whether the Plan Commission's discretionary decision pursuant to the village code to not amend that side setback was appropriate or not. Is there any further deliberation or questions from the board members that they'd like to raise at this time?
I have none.
None.
I have none as well.
I'm prepared to make a formal motion.
Please.
I move to deny the appeal before us and affirm the Plan Commission January 25, 2022 decision pursuant to Village Code Section 531-21B sub C sub 2 to not amend the side yard setback / build-to line for the proposed construction located at 2418, 2420, and 2428 East Capitol Drive.
Is there a second?
I'll second the motion.
Proceed to a vote. All those in favor of Mr. Paulson's motion to deny the appeal and affirm the determination of the Plan Commission at their meeting on January 25th. All those in favor say aye.
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 No.
Okay. And a vote of 2 ayes to 1 no carries the matter. The motion is approved. Attorney Bayer, am I doing this right? Next item on our agenda is item number 8, consideration of requests for a special exception of Village Code 5359G for the construction of a rear yard patio at legal nonconforming residential property 3530 North Downer Avenue. See.
We depart then.
Yes, you may be excused. I'll take a moment before we proceed. Do we have a representative of the village that would like to introduce this matter? Okay, Mr. Burris.
The property owner of 3530 North Downer Avenue is requesting a special exception to replace and expand the rear yard patio, which will increase the degree of nonconformity. The property is legal nonconforming with respect to lot coverage and green space. The village received the building permit application on March 22nd, 2022, and the Board of Appeals application on April 1st, 2022. The applicable zoning regulation is 535-9 parent G that states at least 30% of each lot shall be planted with grass, shrubs, trees, or other forms of vegetation. The conditions of this lot are generally conforming in the area of lot width. Minimum required is 40 feet. This lot is 44. Lot area minimum is 4,500 square feet. This lot is 5,280 square feet. Where it becomes legal non-conforming, again, 30% is the minimum area of grass, plantings, and shrubs. And this property has 24%. Just some background here. The property at 3530 Downer was issued a building permit in July of 1980 to construct an existing 529 square foot 2-car garage where there had previously existed a single-car garage. The requirement that every lot maintains 30% was added to the village ordinances in June of 1985, and that is when this lot became legal non-conforming. The ordinance related to the regulation and use of driveways, patios, decks, and parking spaces. And again, that's when it became non-conforming. They have an existing patio area that's 190 square feet, with the area proposed to be added at 155. The area of green space would be reduced to 21% from 24. And then within the packet, we have some pictures, I believe a survey.
I'll open this up to board members for questions for Inspector Burris. Yes, Attorney Bayer.
Just for the benefit of the applicant, did you want me to go over the
Oh, yes.
special?
Attorney Bayer, can you please give us the standard of review?
Sure, absolutely. So again, this is a little different than the last analysis, and it's a little different than variances, which are normally what comes before this body. So as the inspector has just described, what we really have is a non-conforming structure, which would be the patio area. So we'd be talking about expanding or enlarging that. So under 535-34E, it specifically defines a special exception criteria for this body to review. It says, subject to the provisions of the applicable law, the Board of Appeals, upon an application, may grant a special exception to the provisions of subsection A, which is what we just talked about, which is not increasing a non-conforming structure. And it says that you should consider the following. The first item is the effect the granting of the exception will have on the appearance and character of applicant's property, adjacent properties, and neighboring properties. The second item to consider when deciding whether to grant the special exception is the effect that the granting will have on the value of the applicant's property, adjacent properties, and neighboring property. The third item to consider is whether the granting of the exception will serve the public interest in improving and preserving the value of the property. And the final item to evaluate in determining whether to grant a special exception is it's a catch-all. It says such other matters as the Board of Appeals deems relevant and material. Good, it's the catch-all clause. So really the question here is by expanding the patio, which is, as I understand it, the non-conforming structure that we're talking about here, is because of the sizes that were described. If that gets a little bigger as a result of this proposal, those are the factors to consider. And also in the memorandum that was included by staff along on page 2, you can, if you need to refer to those during the discussion, it's on page 2 of the memo that addresses this specific item. And there's a copy of 535-34E, the special exception criteria.
Thank you. Returning to Inspector Burris, I'm wondering if you can tell me, in the calculation of the green space, which you noted is decreasing from 24% to 21%, are the proposed garden beds included in that potential green space when you're making that calculation?
Yes. So as my understanding is that, yes, the garden beds exist in other areas of the yard, which are green space. The owners may be able to speak more to that. In looking at other municipalities' green space requirements, I know that some do provide different weights to, say, trees and things like that. Ours is very basic.
And is this patio proposed in the backyard area of the property?
It is, yes.
Is any of that area visible from the street?
No.
Any questions from the other board members for Inspector Burris?
None.
Inspector Burris, if I remember the record correctly, the applicant was intending to use patio blocks or something like that. Would that constitute a pervious or impervious surface for purposes of green space counting?
So that has been, I'll say, discussed ad nauseum, and the 30% green space has nothing to do with impervious surfaces or the permeability of a lot. So when the ordinance was drafted, it was, I've got it in here. It was drafted in mind that it is in the best interest in the village to perpetuate attractive street views and neighborhoods, maintain privacy, and encourage the development and preservation of open space in the village. And again, it pertains specifically to driveways, patios, decks, and parking spaces. So the 30% is more of an aesthetic requirement. It has nothing to do with permeability.
Thank you.
Any other questions for Inspector Burris? Hearing none. Do we have a representative for the applicants? Would you mind introducing yourself and providing your address, please?
Jeff Kelly. So the items that I think are but we
Excuse me, I'm sorry to interrupt. The microphone's cutting out so much, I could follow the prior event, but if you'd speak very closely to it, it would help.
yeah, sorry, is that better?
Much better.
I was just saying that we obviously feel that it would it's the value of the property. Currently, the existing patio is sunken. It's not very usable the way it's out with. We'd also like to add stairs that would further increase use. Things like that. That's really all I have.
And it appears from the overhead imaging of this property that the green space appears to be lawn that's currently in place.
If you could call it that, it's currently a dirt patch that turns into mud.
Okay. So the proposal of expanding the patio, would you say it would increase the usage of that area for the homeowners?
Oh, absolutely.
And, well, John, do you have a question?
Yeah, so in consideration of trying to make it a more of a patio, is it also you said there's questionable grass here right now that, it's preventing it? Is it because of the lack of light or clay underneath or?
Mostly lack of light. Be my understanding, it's kind of surrounded.
Okay.
So it's not, in my opinion, way to get.
No.
Going to sort of.
Do you agree that the position of this property, if you were to change, remove the unhealthy sod and replace with patio, would there be an impact on the visual of the home as from the street or from the?
As from the street, no, because from the I believe it would improve.
And that's a good question as to whether we've received any notice of objection to this special exception.
The village has not received any objection, no.
Okay.
One quick question from me. In your opinion, would this have any negative impact on either your property values or the property values of any of your neighbors, immediate neighbors?
In my opinion.
And do you mind telling us your address? 3526. And can we have your name for the record? Katie Ambley. Thank you. Any other questions for the applicants? I have none.
None.
Shall we proceed to a motion? Would someone like to propose a motion on this matter?
I can propose a motion if that's okay.
Proceed.
I move that a special exception of Village Code 535-9 sub G for the construction of a rear yard patio at legal non-conforming residential property 3530 North Downer Avenue be granted.
Do I have a second?
I would second the motion.
Let's proceed to a vote. All those in favor of granting the motion to grant a special exception as stated by Mr. Paulson, please say aye.
Aye.
Aye. That was a
Aye.
aye. Okay. A unanimous vote grants the special exception. Thank you very much. And you can all
Thank
leave.
you.
All right. Well, enjoy your patio. Okay, item number 9, consider of request for a variance of Village Code 535-919, sub F to construct a detached garage within the side yard setback at residential property 4024 North Prospect Avenue. Attorney Bayer, can you clarify the standard for us on this request for a variance?
Sure, thank you. We had to get them all in tonight.
Yep.
Special exception, variance, appeal to interpretation to allow. So when we talk about a variance, and this of course is mostly for the applicant, because I know you all know this, but we're talking about a variance from the code, and the Board of Appeals is expressly authorized by statute and code to hear and grant appeals for variances that would not be contrary to the public interest, where because of special conditions associated with the property, a literal enforcement of the code would result in practical difficulty or unnecessary hardship, so that the purpose and spirit of this chapter, and that chapter meaning the zoning code, shall be observed in the public safety, welfare, and justice. So the general idea is that there's something unique about this particular property that would make it difficult to enforce the code as written. For example, there's a lot of properties in the municipality. There are a lot of lots that were created before the zoning went into effect, and they're non-conforming sizes, et cetera, et cetera. So there's a lot of factors there. And this body has that discretion to grant those. But if you do grant a variance, there are a couple of specific findings that must be made and reflected in the discussion and or the motion. And under 535-58, it dictates that no variance to the provisions of this chapter can be granted unless it finds the following. The first item is exceptional circumstances. It says that there must be exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, parcel, or structure that don't apply generally to the other properties in the same district or in the neighborhood, such that granting the variance would not be of so recurrent nature to suggest that the chapter should be changed. In other words, you don't want the exception to swallow the rule. In legalese, that's basically. So there's one other item that must be specifically found or discussed in the record or be made part of the motion to grant the variance, and that's absence of detriment. And the code says that the variance will not create substantial detriment to adjacent property and will not materially impair or be contrary to the purpose in the spirit of this chapter, again, the zoning chapter, or the public interest. So again, exceptional circumstances and absence of detriment should be the focus of the body and the focus of the evidence submitted by the applicant here.
Thank you. Inspector Burris, do you have a statement on this matter?
Yes. So again, the property owners of 4024 North Prospect Avenue are requesting a variance to construct a 16 by 22 foot detached garage that is proposed to sit in the side yard setback. The village received the building permit application on April 4th, 2022, and the Board of Appeals application on April 18th, 2022. The applicable zoning regulation is 535-19F, parent 5. Side yard minimum setback is 3 feet. The conditions of the lot are that it conforms to the lot width. Minimum is 40. The lot is 40. Minimum lot area is 4,500 square feet. This lot is 5,194 square feet. The existing 12 by 18 single car garage is legal non-conforming as it sits 2 feet from the south property line. Once that's taken down and reconstructed, it now must conform. The proposed 16 by 22 garage will be relocated further east and meet the 3 foot rear yard setback, but they're looking to maintain the 2 foot south side yard setback. And then the applicant has their Board of Appeals application and supplementary materials that they've provided.
I'll open this up for questions to Inspector Burris.
Mr. Burris, is the purpose of the side yard setback at least one of the purposes in order to ensure that there is access to the roof or the side of the garage for future maintenance or safety purposes?
That is the primary reason for the setback, yes. Light ventilation and maintenance access, yes.
And so in this particular case, I take it there would be no detriment to the access on that basis, if the setback was reduced from 3 feet to 2 feet on the south side.
Given that the garage has maintained a 2-foot setback in its current position, and it's been able to be maintained over the years. I believe it is the original garage that was constructed with the house. I don't see anything that would limit it any more than it already has been. So that, no, access would still be available to maintain.
No
What if-
further questions.
What if one of the neighboring properties adjacent to that garage were to construct a fence, a compliant fence? Because the setback in total equates to 6 feet
Yes.
between structures on properties, adjoining properties. If the adjoining neighbor were to construct a lawful fence, wouldn't that limit access to the garage if we were to grant this variance?
It would decrease the available space on that side of the garage.
From your review of the lot, is there anything unique about this particular lot as opposed to any neighboring properties, such as the situation of the home on the lot or any other matters like that?
Nothing in my review that I would say would have been exceptional.
Now, the proposal, I believe, is that the current is a 1-car garage, and it will be replaced with a 1.5 car garage, lining up with an existing driveway.
Yes.
And can you clarify for me that existing driveway is it also legal nonconforming in that side setback?
Driveways do not have to conform to the setback requirements. They can go up to the lot.
Okay, and it appears from the photographs that the driveway currently goes straight back to the edge of the current garage. Is that correct?
I believe so.
Okay. Any other questions for Inspector Burris at this time?
No, I don't have any.
None.
Okay. Do we have a representative for the applicants that would like to make a statement? You can come join us at the podium, and please make sure you speak into the microphone so that Mr. Paulson can hear you. Would you mind introducing yourself?
Andrew Rothrock, 4024 Prospect. And yeah, I didn't know what all we'd have to present tonight. Package. Again, we were going with JD Griffiths, garage door company. We didn't realize that this garage was not even on compliance. I think that's one of the things we wanted to say, is that as soon as he came out, very knowledgeable guy, said, you're gonna have to move this a foot or get a variance. We frankly wouldn't want it because it's already very, very tight to get. This garage is designed for a Model T, small Model T at that. So to try to get an SUV around there is going to be tough anyway. So I don't want to take up too much more of anybody's time except to say that a very modest proposal. Garage floor is complete. We don't want to put good money on $38,000 rebuild.
Is there anything about the lot or the placement of your home or any other structures on the lot that makes it a hardship for you to comply with the current code requirements?
There actually is, and I appreciate you bringing that up. We can only include like the pictures that survey the front of the house, and then maybe line plants inside of our garage. We have a beam that comes down off the back of our porch. As soon as the contractor came, said, you'll never be able, even if they're going to blow up our concrete and put it out, we would never be able to make the back of our house because there's a. That's why, first of all, we aren't going with a 2-car garage. Dialed it back to 1.5, but even at that, we'd have a hard time just getting in. Comes off the back. That's a supporting pipe.
Hypothetically, if you were to just stay with a one-car garage, which I believe is what you currently have,
Mm.
right? If you were to stick with a one-car garage and push it over a foot to meet the 3-foot setback, would you still have that problem with getting a car into that garage because of the beam?
Yeah, it would still be tough. I mean, there's only, the only way we're gonna get a car in there is to leave it on the line, to just come over just a slight little bit. And the extra half a space, you want to put garbage cans inside, son's got a motorcycle, things like that. We'll make use of it. We'll get our garbage inside. That's what we're vehicles. Your question is, you know, would you be able to do it if you moved a one-car garage? We're not gonna the house, whatever we got.
Any other questions for the applicant?
I got a question for you. Have you consulted with any of the neighbors?
Yes.
Especially the one to the, what is it, the south?
Yeah, and that's our neighbor, Ben, Milwaukee police officer, else he might have been here to help endorse us. Anyway, that house had a garage rebuilt just 7-8 years ago, and the original, you know, person that had lived there for like 60 years, and they came with a full 2-side garage. We let him know, you know, bought this house, it's replacing a garage that was ours, and he said, I don't know how you can live with what. And we said, well, someday, that's why we haven't painted it. Someday we're going to try to get this. And when I was out there measuring the line with him, he said, so you're going to move the garage to our property? No, our property is actually over here, and we're just trying to leave it where it is. Yeah, that's absolutely. That's exactly what they said. And again, we have rainwater that comes down the side, and it's like there's a problem with the other people that were describing the mud or swamp around here. We don't get it. Don't get anything. We're going to replace unusable space with extra half foot of a garage, and then on his side, we'll have our rainwater though. Pardon, we allow them to build on our side. I know where the line is. Yeah, they were okay with it. Everybody else is. Every other house is our garage.
Mike, did you have a question?
No, I have not.
Any other statement by the applicant? Thank you for coming. Let's open this up for consideration amongst the board members. You know, it doesn't seem to me that this particular lot is unique compared to others in the neighborhood, although applicants mention of this support beam on the house, making it very challenging for a vehicle to get into any size garage, may be sufficient for us to justify on the basis of unique property of the building and structures on the lot to justify granting a variance. I'd like to hear the opinion of the other board members as to whether we think that's sufficient to justify granting a variance.
For my 2 cents, I think the support beam and the angle of access, proximity of the garage to the house does constitute sufficiently unusual circumstances or conditions which apply to the lot and structures that would justify granting the variance. It's kind of the homeowner to some extent is caught between a rock and a hard place, because he could potentially avoid some of that structural problem if he were to move the garage further back, but then he'd require a variance on the rear yard setback. It seems to me that under the circumstances, given the access, given the location, his proposal to intrude a minimum 1 foot into the side yard setback is a better solution to the fact that he has an access problem between the driveway, the house, and the garage. So I think that's a sufficient unusual circumstance. Clearly will not create any detriment, substantial detriment to any of the neighbors or to the public interest. So I think that gets us within the range of finding an acceptable basis for granting a variance here.
I'd concur with what you're saying there too, Michael, that that in the position the location of the garage in the backyard and where it is in the house. The fact that we're not moving anywhere actually into the neighbors that they have actually already complied with. That this seems like the only relative spot that it could go in.
Shall we proceed to a motion? Would a member like to propose a motion?
I'll propose a motion. Hang on, let me grab my scratch paper. I move that a variance be granted to Village Code 535-19F to construct a detached garage up to 1 foot within the south side yard setback at residential property 4024 North Prospect Avenue.
Do I have a second?
I would second the motion.
Let's proceed to a vote. All members who vote to approve the motion to grant a variance as stated by Mr. Paulson, please say aye.
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 A unanimous decision to approve that motion. The variance is granted. Thank you, and thank you for waiting so long for your matter to be heard. Right. All right, that was the end of our agenda.
I'll move to adjourn.
I'll second.
All those in favor of adjourning this meeting, say aye.
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 All right, this meeting is adjourned as of 7:36 p.m. Thank you.
Great job, Wendy.
Oh, thank you very much.
Yeah.